Good morning. May it please the court.
Hold on, we're waiting for, okay, Mr. Foxall is there.
Morning, Your Honors.
Okay, good morning. Mr. Rosenberg, you may proceed.
Good morning. May it please the court. David Rosenberg on behalf of the appellant, James B. Nutter and Company, referred to as JBN. I'd like to reserve 5 minutes for rebuttal, please.
Okay.
If this court has no immediate questions or concerns, I'll just proceed with my argument. In this case, the parties attempted to settle this matter before trial, and after attending a 4-hour court-ordered mediation the week before trial, the parties reached an agreement and signed a preliminary written settlement agreement. Despite the parties' agreed motion to continue the trial the next week, and despite the parties' repeated protestations to the trial court that they were settling this matter and did not want to litigate it, the trial court denied a continuance and forced the parties to try the case instead of letting the parties amicably resolve it as they wanted to do. This was error. A trial court's discretion on a motion for continuance is reviewed for abuse of discretion, but that discretion is not absolute. That's what this court held in Vollmer. That's a 2007 case. In Vollmer and also in Re DS, this court clarified that it would consider 3 factors when determining whether or not a trial court abused its discretion. Number 1, was there an injustice to the movement with the denial of the continuance? Number 2, was the cause of the request foreseeable or unforeseeable, and was it a result of dilatory practices or not? And number 3, was there any prejudice or inconvenience to the opposing party? So I would like to put those aside for a moment, though, those 3 elements. And I want to first start with something that is not an element in that test, which is the cause of our request. Now, that is not something this court has to consider to determine if the trial court abused its discretion or not, but the cause of the request is important to the disposition of this appeal. Now, Florida's public policy unquestionably favors settlements. And the parties here were not dragging their feet. They were not trying to avoid trial. They were not trying to incur additional attorney's fees and costs. In fact, they were doing the opposite. They were trying to avoid incurring fees for going to trial. They were trying to avoid incurring fees for a motion for a hearing, which we had to file. They were trying to avoid incurring fees for an appeal, which obviously here we are a year later. What the parties were trying to do is they're trying to amicably resolve this. Now, in D'Angelo, and there are many cases to say this, but I'll just cite a couple. In D'Angelo, which is a decision from this court, that's from 2002, this court held the legal system, and indeed our society, encourages settlement to resolve conflict. In Seuss, second DCA, this court from 2009, it is the well-established policy in Florida that settlement agreements are highly favored in the law. And then final quote that I'll give this court, Antar versus C. Miles, is third DCA from 2008, and they're citing the Florida Supreme Court.
Counsel, can you address for me, there was a, the trial was set for June the 19th and the case was mediated on June the 13th. Is that right?
That's correct. It was a Thursday.
And there was a document was generated as a result of the mediation indicating that there was an agreement.
That's correct.
So what happened?
So the mediator filed a report the next morning on Friday. So the settlement, that's right.
On Friday the 14th?
Correct. That's, yeah, June 14th, Friday.
Okay.
And that's at 121 record site. So June 13th, Thursday is the mediation. It goes from 1 p.m. to 5 p.m. The parties mediated for 4 hours. Then on Friday, the mediator files a report and JBN files a motion for continuance at 10:17 a.m. that morning. So,
right.
And then we refiled it again around noon.
This is unopposed, correct?
It is agreed. The actual motions
the purpose for the continuance was apparently to try to work out whatever the details were left hanging after the mediation was finished. Is that right?
Correct. And I don't want to go too much outside the record. I'll try to obviously constrain myself to the record.
I don't want you to go outside the record at all.
Right. Yes. So what the record reflects is there's a preliminary settlement agreement, and what the parties represented is that they needed additional time to finalize that agreement, and they were not able to do that before trial. The motion for
then everybody shows up for trial because the case has not been continued at that point, right?
Well, first we show up the morning. So the trial is scheduled for the next Wednesday, the following Wednesday, and it was set for the afternoon docket. The parties showed up in the morning in the AM and presented their agreed request for continuance. Now, the judge did not indicate that he didn't want to go forward with the trial. The trial judge didn't express any reservations about proceeding with the trial. The trial judge had no opinion on whether or not to proceed with the trial.
And this is the morning of trial or the morning before trial?
The morning of trial, Your Honor.
Okay, so you present this document and then he apparently denies it.
Correct, Your Honor. And the reason he denied it was not because he had any concerns with proceeding with the trial. The reason the trial judge denied it is because, unbeknownst to the parties, because the order wasn't docketed yet, another judge, who was not the trial judge, had denied the motion for continuance. And that order appears later that afternoon around 4 p.m. And it says that just the motion continues denied. And so the trial judge didn't have any problem with continuing the trial. The only reason that the motion for continuance was denied and the trial judge refused to reconsider that denial, which was not of order as yet, was out of deference to another judge who was not even hearing the trial. So that was the only basis, if it could be called that, for the trial courts, the trial judge's ruling. There's
Mr.
not any
Rosenberg,
problem.
Mr. Rosenberg, could I ask you to go back a moment? This was not a situation where you just needed to finalize the documents. My understanding from the record is that there was some separate probate proceeding that was contemplated by the settlement.
So, and this is where I can't get too much into details because unfortunately they're not in the record, but what the record reflects is that the parties needed time to finalize the settlement agreement. Now, whether or not that settlement agreement was complete and just contingent on certain events is outside the record.
Okay.
But what the record reflects is, and the parties said this at the hearing before the court, in the transcript, they said there is an agreement, Your Honor. And,
okay.
And that was my colleague, Mr. Foxall, who said that to the court, and our counsel concurred. So
then at some point, a second mediator's agreement is generated indicating there's no agreement.
Correct, Your Honor. That was after judgment was entered for the defendant. So after the trial was resolved,
okay,
and our continuance was denied, the mediator filed an amended report in which it was changed to no agreement. That's record 134, 135.
So what time was trial supposed to start? In the afternoon?
Correct, Your Honor.
So you show up for trial. Were you expecting to go to trial, or you were expecting to have your continuance granted at that point?
The understanding and the argument we're obviously making here today is that we expected the continuance would be granted because it was unopposed. It would be an injustice to us if it was denied, and there's no prejudice to the opposing party. There are no extenuating circumstances. It's a year-old case. We were just proceeding with trial. So there was no reason for us to believe that the trial court were denied. There's nothing in the record that would support a denial, which is why our argument is that the trial court abused its discretion, that its decision was effectively unreasonable or arbitrary because it is not based on anything in the record. There's nothing in the record that would warrant denying a continuance. The
opposing party was also, it was your understanding, showing up and going to also agree to the continuance. Is that correct?
Correct, Your Honor. They argued for it.
At some point, the opposing party decided that they were going to oppose this. Is that right? Or did they ever?
They did not oppose the continuance, no. Once the trial went forward.
They are opposing your appeal.
They are opposing a very limited aspect of it, yes, correct. They are opposing only whether or not, and their answer brief is confined to this one issue.
So you show up to trial, you think you have an agreed upon continuance, you don't have the witnesses you need to even go to trial, and the judge says, sorry, you got to go to trial or else you lose. Is that kind of what happened in a nutshell?
Yes, it is, though at that time, our counsel didn't realize, at least the transcript reflects that the counsel didn't realize that the witness wasn't present. At that point, at the time we filed a motion for continuance, that was on the Friday before trial. So that was done without respect to whether or not the witness was present. Now, the witness later testified by affidavit that the witness made a mistake and thought it would be continued given Florida's public policy favoring settlements, given the undisputed nature of the continuance, given the lack of any record evidence that would support denying a continuance. And at that point, so our motion for continuance based on a settlement was denied, And at that point, once we realized that our witness wasn't present, which we discovered between the hearing in the morning on Wednesday on our motion for continuance and the actual trial in the afternoon of that same day, that our witness wasn't present, we made a second motion for continuance based on the witness's absence. And we did not know the reason for the absence at that time. And the trial judge said, you may bring that to my attention by motion for a hearing, and I'll consider that as well. So we're appealing.
What was it? And the opposing party's position on that motion?
My colleague did not take a position on that one. He didn't oppose it. He didn't argue for it. The one that my colleague argued for was the first motion for continuance based on those. So that's what we were expecting. And the reason we're expecting that continuance to be granted is because the parties settled. We wanted to amicably resolve this case. We did not want to litigate it. We don't want to incur additional fees. And it was my client's understanding, as is it mine, that Florida's judicial system does not force parties to spend money to litigate each other in court. What it does is it encourages settlement. And I think it's important, and I mentioned it before, but again, to note that the mediation here, it was set by the court. So the court set this mediation for the Thursday before the Wednesday trial. So the court knew, or it can be presumed to have known, that this mediation could have resulted in settlement. And it was the court itself that was encouraging the parties by setting this mediation to settle. And we went ahead, we filed the court's directions, we followed the court's order, we attended mediation for 4 hours. We reached I think the record reflects it's a complicated case because it involves probate and other things, which I won't get into because that's not on the record. But what it does reflect is that there was a complicated settlement, and the parties needed additional time to just finalize it, to go through the steps, and to work out a complete written agreement. Obviously, when you go to mediation, you don't have a computer there to type out and print and run by every single term. So what the parties did is what you normally do at mediation. The parties entered into a preliminary written settlement agreement, laying out generally that they had reached an agreement and that this is what they needed to do. And they wanted the trial to be continued so that they could complete their settlement. Not because there was a possibility of settlement. I think that's important because my colleague argues that we should have known there was a possibility of settlement before the mediation and so on and so forth. No, the mediation resulted in a settlement. That's what was represented at the hearing before the trial court. My colleague represented that, our trial counsel represented that. It is undisputed on appeal that there was a settlement between the parties. So I think I've covered, as I said in the beginning, the cause for the request, which is the settlement between the parties, which is highly favored in Florida law. I've covered the 3 elements that this court talked about in Vollmer and In Re DS. And then the final thing I want to touch on as well, and this is not a factor that this court must consider in determining whether or not there was error below, but I think it's equally important, is what was the impact on the trial court? And I briefly mentioned this. So this is not an element. You only have to consider the prejudice or inconvenience to the opposing party. But was there any prejudice or inconvenience to the trial court, to its control over its docket? There was none. The record discloses no prejudice or inconvenience to the trial court. The trial court, as I mentioned, didn't even have a personal problem with continuing the trial. The trial court's only reason for denying a continuance was because out of deference to another judge who had apparently reviewed and ruled on the motion for continuance. And that other judge was not the judge who was trying the case. So we have the reason for the request for continuance, highly favored under Florida law settlement. We have met the 3 elements. Again, the injustice to the movement. We were unable to settle this case and we had to expend fees that nobody wanted to expend. The cause for the request was unforeseeable prior to Thursday at 5 p.m. when we settled, and we filed the motion the next morning at 10:17 a.m. So that was not dilatory. And then the final thing, again, there's no prejudice or inconvenience to the opposing party because they agreed to it. And not only did they agree to the motion for continuance, they argued in its favor before the trial court. So you have those. And then in addition to those, you have the trial court itself expressing no concerns about continuing the trial, but just deferring only because it was under the impression another judge had already ruled on this motion unbeknownst to the parties at that time. So that is our argument. Our argument is that a trial court's decision on a motion for continuance is afforded abuse of discretion standard review. But that discretion is not unbounded. It is limited by the facts before the court. And those facts undeniably favor a continuance. There is zero evidence in the record suggesting foot dragging, suggesting any reason for the trial court to deny continuance. There was no reason for the trial court to deny continuance. And that is why we submit that the trial court's decision was effectively unreasonable and arbitrary, i.e. an abuse of discretion. And then there was just one final thing I want to touch on. I briefly mentioned it before, and this is a very straightforward case, as I'm sure your honors understand. The final thing I want to touch on before I'll let my colleague speak is what my colleague can argue. Now, my colleague doesn't dispute any of these points on appeal except for one. My colleague disputes that whether or not the motion was timely, the request for continuance. And my colleague suggests that JBN should have known that the mediation would result in a settlement agreement and should have moved for a continuance earlier. Now, this position, the single argument that my colleague makes in the answer brief is incorrect for two reasons. One, as we explained in our reply brief, we weren't requesting a continuance because of the possibility of settlement. We were requesting continuance because the parties had actually settled. And number two, there is nothing in the record reflecting or suggesting my client's, JBN's, pre-mediation knowledge. There's nothing suggesting that JBN knew that the mediation would result in settlement. If anything, the record reflects the opposite. The parties litigated for 4 hours, and after those 4 hours, they only had time to write up a preliminary settlement agreement. So my colleague's arguments are either contradicted or go beyond the record of an appeal. And if this court has no further questions on that.
Okay. Thank you, Mr. Rosenberg. You'll have your rebuttal time.
Thank you, Your Honor.
Maybe Lisa Court, Roy Fox on behalf of Melanie Cosby. It's true we were going to continue the case. I didn't expect to go to trial that day where I was forced into it. But the temperament of this judge, we were in front of a foreclosure docket judge. It's not who the case is actually assigned to, just somebody handling the foreclosure docket that day. So the judge was Judge Laboda, who had originally denied the continuance. So, you know, the plaintiff didn't have their witness there. It was a complex case. Could the judge have denied the motion for continuance based on not having a full settlement agreement? Yes. And was that foreseeable? Yes. And that's our basic argument. And otherwise, what appellant's counsel said is all true. I did not expect to have to go to trial that day.
Okay, that's it.
That's it. Nothing
Thank
further.
you, sir. Mr. Rosenberg, do you have anything else you want to say?
If your honors have no further questions, we would just ask for a reversal and an opportunity to amicably resolve this case instead of being forced to further litigate it with another action.
Very good. Thank you. Thank you both. That concludes our docket. We are adjourned.